Welcome to Damages, video 1 of 3. In this video, we will discuss the introduction of damages, including but not limited to nominal damages, economic damages, and uneconomic damages. Now, up to this point in the negligence framework, the analysis has been on whether the defendant is legally liable for the plaintiff's harm, right? To do this, we've asked a series of related questions. First, we asked, did the defendant owe the plaintiff a duty of care? If that answer was yes, then we identified the duty of care or the standard of care. Second, we asked whether the defendant breached that duty of care by acting in a way that fell below the standard. Third, we asked whether the defendant's conduct actually caused the plaintiff's injury. And then finally, we asked whether the injury falls within the scope of liability, also known as proximate cause. Now, that final question, the proximate cause question, the scope of liability question, required us to determine whether the harm that occurred was the kind of harm that made the defendant's conduct negligent to begin with. Now that we've established those necessary requirements, we look to the defendant's legal liability and how the court determines or how the law determines the remedy for that harm. And that is the work of the last element of negligence, which is damages. Damages are usually defined as monetary awards, right? Usually defined as monetary awards that are meant to compensate a person for a loss or an injury caused by the wrongful conduct of another. Well, why money? Let's just be honest. People like money. In addition to the fact that people like money, let's look at the reality of the situation. The law is limited in the relief it can offer those that the law has deemed to be harmed or injured, right? The law does not allow for us to go back in time for the injury to be undone, for the broken bone to be healed, for the trauma to not have been caused, for the loss of life to be restored, right? So money damages, money is the currency that currently serves to substitute those harms and injuries. Now, that's not to say that restorative justice isn't important, and that's not to say that there's no place for restorative justice, because there is. But as we learn the doctrine as it currently stands and the limits for the current doctrine, we're going to start with the currency that we use mostly, which is money damages. To understand how courts approach damages, it's helpful to take a step back and examine the overall structure of the damages doctrine. So here's the basic structure. We have compensatory damages and we have punitive damages. Compensatory damages are intended to compensate, restore. Punitive damages are intended to punish or deter. Got it? Compensatory damages, compensate. Punitive damages, punish. Here's another way to look at it. Compensatory damages may include economic damages, also known as pecuniary damages. That might be medical expenses, lost wages, loss of earning capacity, property damage. Compensatory damages may also include non-economic or non-pecuniary damages, pain and suffering, emotional distress, loss of enjoyment of life, disfigurement, right? So those are our compensatory damages. But before we go too much further into the category of either compensatory or punitive, we need to take a look at a category of damages that is outside of that binary structure. And those damages are called nominal damages. Nominal damages are small monetary awards, oftentimes $1. Monetary damages are given when a legal right has been violated, but the plaintiff cannot prove actual economic or physical loss, right? Plaintiff cannot establish actual economic or physical loss. The purpose of nominal damages is not compensation. The purpose of nominal damages is recognition. Nominal damages express a basic proposition of tort law. A legal wrong may be actionable even when it produces no provable, measurable loss. Got it? All right. Let's go to the first case that we had assigned, and that's the Doherty v. Stepp case. Yes, it's 1835, but it still works. What's going on in that case? Well, let's just jump into the facts. We have the disputed ownership and possession of land. Two neighbors, property line dispute, right? Plaintiff, Mr. Doherty, was in lawful possession of the land. Defendant, Mr. Stepp, was not in lawful possession of the land, but felt as though he had a claim to a portion of the land. Well, what's the best way to get that resolved? Get some surveyors out there and let's survey the property. What's the problem? The problem is Mr. Stepp and the surveyors went on to Doherty's land without Doherty's permission, even though the defendant believed that part of that property was rightfully his. What do we learn from first semester with intentional torts, right? You step on that land either because you believe it's yours, or even if you don't believe it's yours, when it's in the rightful possession of someone else, you've got an intentional tort of trespass. So going back to the damages piece, entry by the defendant and the surveyors did not cause any measurable physical damage. Of course, they entered the land without permission. They walked on the land because that's what you have to do. They made some markings on the land because if you've ever had anything surveyed, that's kind of what they do. They mark it all up, but not to the extent of any measurable physical damage. Nevertheless, Mr. Doherty sued Mr. Stepp for trespasses, right, and sought damages. At trial, the defendant, that's Mr. Stepp, argued there was no actual damage. What is the problem? I want to get this property dispute resolved. I'm sure just for peace sake, you want to get the property dispute resolved as well. So let's get the surveyors out. Let's get it done. Again, because the property was said to be in the lawful possession of Mr. Doherty, and because Mr. Doherty had not given permission for Mr. Stepp and the surveyors to come upon his land, that's a trespass. You have to have damages. Sometimes the damages are nominal. And we talked about this very briefly when we talked about intentional tort. So, what's the issue in Doherty v. Stepp? Here's one. Under the common law doctrine of trespass to land, does a defendant become liable for trespass and nominal damages when the defendant intentionally enters another person's land without permission? Yes, even though the entry of that land causes no measurable physical damage. Yes, yes, that subjects the trespasser to nominal damages. Okay. At common law, any intentional and unauthorized entry onto the land in the possession of another constitute trespass, and the plaintiff is entitled to nominal damages even when no measurable physical harm to property is proven. Get it? Nominal damages is available. Now, I understand that we're talking about an intentional tort, and I also understand that we're talking about damages as the last element of negligence. The tort damages are the same. The tort damages are the same. So I can talk about nominal damages as we get to the last element of negligence, which is damages, because the tort elements are going to be the same. The tort damages, are going to be the same. Get it? So what does Doherty stand for? This case stands for a foundational principle. What is that? The principle is, if you violate another person's legal right, and if the law establishes that liability exists, then you may be subject to damages, even if there is no measurable harm. Those damages would be nominal damages. Get it? Okay. All right. So that is our discussion of nominal damages. At the outset, tort damages contain two distinct ideas. One, vindication. That is, the law recognizes that a wrong has occurred. That's when you may utilize nominal damages, right? There's no measurable damage, but you want to acknowledge that a wrong has occurred, nominal damages. And then the other idea is compensation, right? The law attempts to repair the consequences of that wrong. Now, don't forget, we will get to punitive damages as well, where the law intends to punish the wrongdoer. But again, this was an introduction to nominal damages, a brief application of the rule for nominal damages, and a proper closing of the doctrine of nominal damages. Most tort cases involve more than just a bare violation of a right, right? Most tort cases involve actual injury. For instance, physical damage, economic harm, emotional harm, property related harm, right? Once actual harm is shown, the law shifts from mere recognition of a wrong, nominal damages, to compensation for the loss, right? Once an actual injury, actual harm is established by law, the law moves from merely recognizing a wrong and moves to attempting to compensate for the loss. That movement from nominal damages to compensatory damages can be seen through two related cases, which we're going to apply these rules to now. That is the Bosberg v. Putney case and the Ben v. Thomas case. Both of these cases teach that once the defendant is found to be legally liable for the injuries or the harm suffered by the plaintiff, tort law will attempt to compensate the plaintiff for the injury that actually occurs, even if the severity of that injury is not expected. Did y'all hear it? Even if the severity of the injury is not expected. What did I just tease up? Eggshell skull. Yeah, I just teased it up. But let's stay on track. Let's turn our attention to the Vosburgh v. Putney case. That is Vosburgh v. Putney. And this is a case that exemplifies liability for the full extent of the injury. Got it? Remember, Vosburgh got one kid kicking another kid. All right, so there's my thank you clip art, my attempt to be creative. Briefly, the facts. Case involved two schoolboys attending same classroom. During the class, the defendant, Putney, lightly kicked the plaintiff. Putney lightly kicked Vosburgh, right? Seems like they were playing and joking around, whatever. He kicked him. Vosburgh, unbeknownst to anyone, had a pre-existing medical condition in his leg that made his leg unusually vulnerable. The kick by Putney aggravated a pre-existing condition, right? The kick aggravated a pre-existing condition. The injury, therefore, required multiple surgeries and extensive medical treatment, right? The plaintiff suffered permanent impairment of that leg. So the parents for Vosburgh sue the parents for Putney. And I because these are children, understand, right? These are children. So their guardians, whoever it is who is held responsible for their welfare, brings a lawsuit on behalf of the child. And so the plaintiff is seeking damages for this permanent impairment of their leg. Putney argues the contact was so minor and so harmless, right, that he should not be held responsible for the severe consequences that followed. He had no way of knowing about this undisclosed vulnerability, right? So what's the issue in Vosburgh? Under the law governing damages, does a defendant become liable for the full extent of plaintiff's injury when? Do you see how it's set up? What law are we looking at? Damages. What question do you want me to answer? The question is, does a defendant become liable for the full extent of the plaintiff's injury? Well, give me some context. The full extent of plaintiff's injury when? When the defendant commits an unlawful physical contact that aggravates a pre-existing medical condition. Ooh, right? And if I want to set it up even more, a pre-existing medical condition and produces unexpectedly serious harm. What do you think the court says? Yes. Eggshell skull rule. I said eggshell plaintiff rule here, but it's the eggshell skull, right? A defendant takes the plaintiff as the defendant finds the plaintiff and is responsible for the full extent of any resulting harm. So what does that mean? That means that the court held yes. The court held that because the defendant committed an unlawful contact, why was it unlawful? Because he didn't have consent, right? We don't mean unlawful like people getting ready to go to jail. This is not criminal law. This is civil law, right? So he he, being the defendant, made a harmful or offensive touching to the person or the third person of the plaintiff that resulted, right? We've got our harmful and our offensive result. So the court held that because the defendant committed an unlawful contact, he was liable for the full extent of the plaintiff's injury, even though the severity of the harm was not foreseeable. We're not looking at the severity of the harm, and our foreseeability is not to the extent of the damage. What are we looking at when we look at proximate cause? We're looking to see if the kind of harm, not the modality of the harm, the kind of harm, not the severity of the harm. We are simply looking at, is the harm that resulted the kind of harm that you would anticipate to be the result of the negligent or intentional behavior. If there's alignment, we've got liability. Get it? If there's alignment, we've got liability. Well, how far does the eggshell skull plaintiff rule go? Is it limited only to medical conditions? No. The doctrine applies whenever the plaintiff has a pre-existing vulnerability, that makes the injury more severe than what would have been in an average person. Okay, so let's look at the scope. We're going to go 4 inches deep, right? Number one, what type of vulnerability? It can be a pre-existing medical condition. These are examples just to illustrate. These are not exhaustive. An example, fragile bones. An example, heart disease. An example, prior injury. Here's an example. A minor bump causes a catastrophic injury because the plaintiff had a pre-existing bone weakness. That's just an example, right? The defendant is still liable for the full extent of the harm. Those are examples of pre-existing medical conditions. Well, if it's not limited to medical conditions, what else does this eggshell skull plaintiff rule? Where else does this scope reach? Physical fragility. Sometimes the vulnerability is not a disease, but a physical characteristic. For instance, an elderly person with fragile bones, a very small child with little bones, right? Unusually thin skulls. That's just a physical fragility. So the scope of the eggshell skull plaintiff rule reaches physical fragility. What's the third area that this rule reaches? Psychological or emotional vulnerability, right? This rule can also apply to psychological conditions. For example, a negligent accident triggering severe depression might be harder to establish, but it is not impossible to establish. Maybe PTSD may be hard to establish, but it's not impossible. What is the fourth area that the eggshell skull plaintiff rule may extend to? Hidden or unknown vulnerabilities. For example, the defendant does not need to know about the vulnerability, of course, because rarely would the defendant know, right? Rarely would the defendant know. So the defendant has no defense in saying, I didn't know. Had I known, I would not have. Mm, you probably just should not have anyway. Okay. As we explore the scope of the eggshell skull rule, please don't misunderstand what's happening from a systemic process of the doctrine. Please do not misunderstand what is happening. The eggshell skull rule is not eliminating causation, right? The eggshell skull rule is not eliminating causation. The plaintiff still must prove the defendant committed the tort. The plaintiff still must prove actual causation. We know that the defendant must prove that the harm falls within the scope of liability, which is proximate causation, right? So this rule is not eliminating causation. This rule gets applied after we have liability. Go back to the videos where we are looking at third restatement torts, section 29, which is the three-step algorithm for proximate cause, and 34, which is the four-step algorithm for intervening and superseding causes, right? We still have to establish the causation, but once that is done and the defendant is found to be liable, then the defendant is going to have to take the plaintiff as they found them. Tort law measures damages. Tort law measures damages that are based on the injury that actually occurred, not the injury that would have occurred, let's say, to a hypothetical average person, right? Tort law measures damages that are based on the injury that's actually occurring. Be mindful. That is a really easy multiple question setup. All right, let's move on. We've got another eggshell plaintiff case, and that is the Ben v. Thomas case. We have another eggshell plaintiff case, and that's the Ben v. Thomas case. All right, what's going on in Ben v. Thomas? Well, I believe it was during the month of October. We've got some icy road conditions, and what we have is a semi tractor and trailer that rear ends a van. Got it? Semi tractor and trailer rear ending a van. The van has a passenger by the name of LaRosse J. Ben. So Mr. Ben was a passenger. When the tractor trailer rear ended the van, there was some damage to the van, and Mr. Ben, as a passenger, was injured as well. In that accident, Mr. Ben suffered a bruised chest and a fractured ankle. 6 days later, Mr. Ben died of a heart attack. Ouch, right? Died of a heart attack. Mrs. Ben, acting as the executor of Mr. Ben, filed a suit against the defendants. That's Mr. Thomas, who was the driver of the tractor trailer, the owner of the tractor and trailer, the permanent lessee of the tractor and trailer, right? She got all of them. She sues for damages and loss of life, right? So the plaintiff is suing, that's Mrs. Ben, for damages against all of the defendants, right, for negligence and loss of life. What's happening? At the trial, the medical expert testified that the plaintiff, Mr. Ben, had a history of coronary disease and insulin-dependent diabetes. that Mr. Ben had a heart attack previously in 85 and was at risk of having another heart attack. The medical expert testified that that's the medical expert, viewed the accident that the plaintiff was in, right? And the attendant problems that were caused, right? As the straw that broke the camel's back. What are we talking about? We are talking about taking the defendant as you find them. Now, understand, other medical evidence indicated that the accident did not cause the death. Dr. Devia said that the accident did cause the death. Other evidence said that it didn't. Based on Dr. Devia's testimony, the plaintiff, the estate of Mr. Ben, requested a jury instruction. What was that instruction? The eggshell plaintiff rule. The district court denied the request. Jury came back for a verdict on behalf of Mr. Ben for $17,000 for injuries, not for loss of life, right? In the special verdict form, the jury determined that the defendant's negligence in connection with the accident was not the proximate cause of Mr. Ben's death. What's the issue? Under the eggshell plaintiff doctrine, does a defendant become liable for a plaintiff's death when a negligent accident triggers a fatal heart attack due to the plaintiff's pre-existing heart condition? What was the holding? Yes. The court held that the defendant was liable because the negligent accident precipitated the heart attack. What does tort law require? Tort law requires that a defendant take the plaintiff as the defendant finds the plaintiff, including pre-existing vulnerabilities. Got it? You take the plaintiff as you find the plaintiff. A negligent defendant takes the plaintiff, one more time, with illustrations, as the defendant finds the plaintiff, including pre-existing conditions. All right, think about it. Once tort law recognizes that a defendant may be responsible for the full extent of the plaintiff's injury, the next question becomes how the legal system measures the compensation. How do we measure the compensation? We say that you are entitled to compensation. We say that we have established legally that the defendant is liable and is the actual cause. How is the injury measured? Well, that brings us to compensatory damages. The central principle of compensatory damages is called the make whole principle. The make whole principle. The idea is pretty straightforward, right? A successful plaintiff should receive enough compensation to restore as nearly as money can to the position the plaintiff occupied before the injury occurred. A successful plaintiff should receive enough compensation to restore them as much as money can to the position that they were in before the injury occurred. Courts sometimes describe this objective as the plaintiff status quo ante rule. The plaintiff's status quo ante, A-N-T-E, before rule, right? That is the condition that existed before the harm. The purpose of compensatory damages is therefore restoration, not punishment, compensation and restoration. So the goal of compensatory damages, the make whole principle, restoration to the extent that money can, return the plaintiff to the status quo. Compensatory damages, right? Compensatory damages. Just look at the word compensatory. Compensate, right? Compensate. Here's an illustration. Suppose a person loses the use of a dominant hand in an accident caused by negligence. If the jury awards the person that just lost the use of their dominant hand $10 million, has the law truly restored the plaintiff? Of course not. No, the answer is no. There is no complete restoration, right? The plaintiff still doesn't have use of their hand as they had it prior to the injury, right? The law hasn't reversed the injury. It's only substituted the injury. It's only tried to compensate as best it can with this substitute currency, right? That's why the make whole principle is aspirational rather than literal. The make whole principle is aspirational rather than literal. Let's look at these compensatory aspirational damages. We've got two forms. We've got economic damages, also known as pecuniary damages, and we have non-economic damages, also known as non-pecuniary damages. What is an economic damage? One that I can calculate. What is a non-pecuniary damage? One that I'm at best guessing at. Right? You see the difference? Economic damages, give me a hospital bill. I can tell you 1,527,000. Boom, there's the numbers, right? Lost wages. Well, how much do you make? $2,500 an hour. How many hours do you usually work? 40 hours a week. Multiply $2,500 by 40 hours. How many weeks do you work? 52, right? Those are numbers that can be calculated with what I'm going to use now is quote unquote real numbers, right? Those numbers are generated from someplace. I can pick up an invoice. I can pick up proof of what my hourly rate has been billed at, right? I can tell you, right, if I can't work 52 hours a week, 52 hours a year, 40 hours a week at $2,500 an hour, right? You can calculate that. You might have to pull out a calculator, but you can calculate that. Property damage. What do I need? All I need to get is a bid as to how much it's going to cost. What are the materials? What are the labor? How much is the labor per hour, right? These are things that I can't tangibly calculate them, but these are numbers that I'm not having to create to rely on. Now, what is a non-economic damage or a non-pecuniary damage? We classify non-economic damages as human losses, right? Human losses, pain and suffering. How much does that cost? Oh, better ask the expert. Emotional distress. How much is that worth? There's no table out there, right? You better ask an expert. Loss of enjoyment of life. How do you value your life and the amount of joy that you have in that life as compared to somebody else's life? Better ask an expert. What about disfigurement? Well, disfigurement is different than restoration, right? Disfigurement assumes that you've had all of the restorative medical treatments that are available and you're still disfigured. How much is that worth? Better call an expert. Get it? So The two, I just realized a typo there, and I'll fix that before I post this PowerPoint. The two categories of compensatory damages are economic and non-economic. Get it? I know that punitive is on the chart, but we're not talking about punitive yet. We're talking about the two types of economic damages. Two types of compensatory damages, economic and non-economic. So economic damages, again, compensate the plaintiff for the financial losses that are caused. These losses often involve expenses that the plaintiff has already incurred or income that the plaintiff has already lost as a result of the defendant's conduct. Because these losses involve financial transactions, courts often rely on documentary evidence such as invoices, employment records, etc. Get it? Economic damages. For example, medical expenses. What is my proof? Hospital bills, surgery invoices, medication receipts, right? Rehabilitation cost. What is my proof? The physical therapy logs and invoices. Lost wages. How do I calculate that? What was I making before my injury and how was I paid? Was I paid per hour? Was I paid per job, right? Loss of earning capacity. That is going to be a future calculation. Loss of earning capacity. I'll talk to you about that in just a moment. But loss of earning capacity is economic, right? Because I can't figure that out, right? There's going to be a little speculation involved, but I can pinpoint in a really close range what the capacity would have been for me to work, but for this injury, right? And then again, we talked about property repair or replacement, right? What's my proof? Invoices, bid sheets, quotes, right? That's stuff that I can really put together relatively easy. Because these losses involve financial transactions, courts again are going to rely on documentary evidence. Now, with that being said, I gave you the caveat. Even economic damages, however, can present difficult questions. For example, when a plaintiff suffers a permanent injury that reduces their ability to work in the future, courts must estimate what the plaintiff's earnings would have been, right? That is the calculation of a future number. See the importance of experts, right? The importance of experts. Very quickly, let's take a moment to discuss the difference between lost wages versus lost earning capacity. Lost wages is income that I've already missed, right? I lost my wages for yesterday. I couldn't go to work yesterday. Those wages are lost. I lost my wages for last year. I couldn't go to work because of the injury last year. Those are wages that I lost. Loss of earning capacity is the loss of my ability to earn in the future. Get it? While a plaintiff may return to work and still recover for diminished earning capacity, if the injury has narrowed future opportunities, if the injury has reduced sufficiency, if the injury has shortened the work life of the plaintiff, then that is going to have a direct impact on their ability to earn in the future. Lost wages or wages that I lost. That opportunity to earn them is gone. Lost earning capacity is the inability to earn in the future. Get it? Here's an illustration. Suppose you have two plaintiffs. Let's say they suffer the same injury. Let's say each loses the use of a finger. It was an accident caused by the defendant's negligence. Let's say the first plaintiff is a construction worker. The injury is serious, but the plaintiff may still be able to perform job functions, right? Once they've healed, once they've recovered, once they've done rehab, once they've retrained, right? So they might have some lost earning capacity in the immediate future, but they may get back to pretty doggone close the ability, the capacity to earn a living in the way that they had earned it before the defendant's negligence caused them harm, right? Let's say the second plaintiff is a concert pianist. Yeah, for that plaintiff, the same lost finger, the same physical injury may destroy their entire future in that profession. Get it? We've got the identical injury, both from negligence of a defendant, but the future ability to earn in the profession that you were earning before the defendant's negligence, right? Those economic consequences are not the same. Get it? Earning capacity. Economic damages. We've got past financial losses, lost wages, future financial losses, that's loss of earning capacity. Yeah? Economic damages are going to attempt to measure the financial losses that can be calculated with relative precision, right? Is going to attempt to measure as close to precise as possible. With that, we're going to end lecture video 1. With that, we come to an end of lecture video 1. Lecture video 2 will start with non-economic damages. That's the non-pecuniary damages. And then we will continue to move through the difficulty that it takes to evaluate non-economic damages, right? These are non-economic damages. What do we call those? We call those human harms. And the difficulty that you have in trying to put a dollar value on human harms. Thanks for hanging out with me for video 1 of damages. Look forward to you coming back for video 2. See you next time.